Richard Moore will be put to death after being convicted of killing a store clerk a quarter-century ago. The state has set a date for its second execution in 13 years. Moore will have about a week to let the state know how he wishes to be killed. If he makes no choice, the state will send him to the electric chair by default. Authorities said Moore went unarmed into the store to rob it and killed store clerk James Mahoney in a shootout.
Richard Moore, a South Carolina capital punishment inmate on the row, has chosen to have his life ended by lethal injection for the slaying of a store clerk in 1999. Moore, now 59, was convicted of ending James Mahoney, a convenience store clerk, during an attempted robbery in Spartanburg County. Though he initially entered the store unarmed, Moore took one of Mahoney's two arms during a scuffle and shot him, taking the clerk's life. Moore himself was wounded during the tragedy, with his blood found on Mahoney's body. The scheduled ending, set for November 1st, marks a significant moment in South Carolina, as it follows a 13-year pause in row endings due to difficulties in acquiring the necessary drugs for lethal injection. Moore's case brings attention to several legal and ethical questions, particularly given the racial dynamics of his trial and the fact that Moore was unarmed when the incident began. His lawyers argue that Moore is the only inmate on South Carolina's finality row who was convicted by an all-white jury and that he initially acted in self-defense. They also highlight that if this proceeds, Moore would become the first person in modern South Carolina history to be put to end after being unarmed at the start of a crime. Despite choosing lethal injection over electrocution or firing squad, Moore's legal team is appealing to the U.S. Supreme Court to halt the act. They hope to challenge the conditions surrounding his case, including the lack of racial diversity on the jury. Whether the appeal will succeed remains to be seen, but Moore's decision to opt for lethal injection underscores the gravity of his impending fate. The case, reflecting long-standing debates about the capital penalty, racial justice, and self-defense, continues to raise questions about the ethical application of capital punishment. Will Moore's punishment go ahead as planned, or will the Supreme Court intervene?
The incident happened in Spartanburg County, where Moore went in unarmed to something that was called Nikki's Speedy Mart to rob the store. On November 1st, Richard Moore will be put to death for killing a store clerk back in 1999. Only a man on the state's death row who's convicted by a jury that did not have any African Americans on it. And that's when authorities say he killed James Mahoney in a shootout after taking the gun from Mahoney.
State makes preparations. According to Sterling, South Carolina has tested and ensured the availability of all three potential methods: lethal injection, firing squad, and the electric chair. Technicians at the state crime lab confirmed that the pentobarbital, the single drug to be used for the injection, is pure, potent, and ready for use. This testing, according to a certified letter sent to Moore, affirms the drug's suitability for the pending act, which will proceed under the state's updated one-drug protocol. South Carolina has previously used a three-drug cocktail for lethal injections, but this case will follow a new approach, similar to that employed by the federal government, involving a single dose of pentobarbital. This method was first used in the state on September 20th in the case of Freddie Owens. Owens' end, carried out under a newly implemented privacy law, reportedly showed no obvious signs of distress. The law, passed last year, protects the identity of the drug manufacturers, making it easier for South Carolina to procure lethal injection drugs. Before this law was enacted, companies refused to sell the necessary drugs, halting ending penalties in the state for over a decade. In Owens' case, his legal team sought additional information about the pentobarbital used in his case, arguing that more transparency was needed about the drug's quality. However, the state Supreme Court ruled that Sterling's assurance of the drug's purity, stability, and potency was sufficient. This precedent carries over to Moore's situation, with his lawyers receiving the same information about the drug's effectiveness for his upcoming punishment.
Claiming the governor cannot fairly grant or deny clemency because of his previous role as the state's attorney general. A South Carolina inmate who's on death row filing a lawsuit against Governor Henry McMaster.
Richard Moore is set to be executed November 1st. Moore was convicted of killing James Mahoney during a robbery, or elected to be executed by firing squad after he was told lethal injection wasn't an option. But now the state was previously forced to pause executions because its supply of lethal injection drugs expired.
Moore's legal team is currently preparing a clemency request, arguing that his demise sentence is disproportionate to the crime. Moore did not enter the convenience store with a weapon and claimed he only fired at clerk James Mahoney in self-defense. The lack of surveillance video from the 1999 shootout complicates the case, as there is no definitive visual evidence of what occurred during the incident. Moore's attorneys point out that their client has maintained good behavior during his time in prison, with no disciplinary violations on his record. They argue that Moore, who has spent over 2 decades behind bars, should be allowed to continue his positive contributions to the prison community. In addition to his clean record, Moore is offered to mentor and rehabilitate fellow inmates if his life is spared. His commitment to helping others behind bars is echoed by his family, who emphasize his transformation. His son, Lyndall Moore, has spoken publicly about his father's role in their lives, describing him as a deeply religious and family-oriented man. Moore has remained as involved as possible in his children's and grandchildren's lives, continuing to offer guidance despite his incarceration. According to Lyndall, Moore's efforts to mentor young people within and outside the prison reflect his growth and rehabilitation over the years. Despite these efforts to secure clemency, the case presents complex legal and moral questions. Moore's defense hinges on the argument that his actions were a result of self-defense, and that the circumstances of his case warrant a lesser sentence than demise. The state, however, maintains that Moore was responsible for Mahoney's demise and should face the ultimate punishment. As the penalty date approaches, attention has turned to whether Moore's appeals and clemency requests will succeed in halting the lethal injection. His case, particularly the claim of self-defense and the racial dynamics of his trial, highlights the ongoing debates around the ending penalty in the U.S. Will Moore's efforts for clemency prove successful, or will the state proceed with its second execution after a 13-year hiatus? These questions loom large as Moore's legal team races against time to save him from the punishment, while the state asserts its readiness to carry out the sentence under its newly refined protocols.
Further review, and that his team is prepared to take Moore's case to the U.S. Supreme Court if necessary.
I'm really grateful that the Supreme Court stayed this execution so that there can be time for further review of Mr. Moore's case. It is just a brief order. It says there will be more details coming, so we don't know exactly what it will mean going forward, but evidence is clear that he entered into the convenience store without a weapon that the death penalty is supposed to be reserved for. And so that's our argument for why there should be more review of his case in particular, which shows that his crime doesn't have the kind of premeditation that raises it to be the worst of the worst.
He said they are going to look closer at the full text of the order, which has not yet been released.
Clemency decision under scrutiny. South Carolina Governor Henry McMaster holds the sole authority to grant clemency for Roe inmate Moore, potentially reducing his sentence to life without parole. Historically, no South Carolina governor has granted clemency in the modern era of the penalty sentence, making this an unprecedented possibility if McMaster chooses to exercise this power. Moore's legal team has taken steps to challenge McMaster's role in the decision-making process. This week, they petitioned a federal judge to remove the decision from the governor's hands, arguing that McMaster had already shown bias by publicly stating in 2022 that he had no intention of commuting any demise sentences. However, U.S. District Judge Mary Geiger Lewis seemed unconvinced by their arguments. McMaster himself has voluntarily submitted a sworn statement affirming that he would follow the legal process and fulfill his obligations under the law, despite his previous remarks. This legal wrangling highlights the tension between executive authority and judicial oversight in capital punishment cases. Moore has come close to his final hours twice in recent years. Each time, the South Carolina Supreme Court intervened to delay the process, citing legal questions about the state's use of the firing squad and the SHIELD law that protects the identities of drug suppliers for lethal injections.
His attorneys challenged it because firing squad wasn't a method of execution when Moore was sentenced in 2001. Now, Governor McMaster has the authority to grant clemency and reduce death sentences to life in prison without parole. Moore is now asking for his clemency application to be looked at by the state's parole board instead, because of both his previous role as the state's attorney general and comments he's made about Moore in the past.
In 2022, Moore initially opted for the firing squad, a rare method of ending in the U.S. having only been used 3 times in the past 50 years, all in Utah. However, this choice was made before South Carolina managed to secure the drugs needed for lethal injection, which became available again under a new privacy law that shields the identities of suppliers. Firing squads and electrocution, though still legal in some states, have become increasingly uncommon as penalty methods. Electrocution has not been used in the U.S. for almost 5 years. The return of lethal injection as an option in South Carolina has shifted the conversation, as it is seen as a more standard method compared to firing squads or electrocution, which carry more historical and ethical baggage. Since the reinstatement of the penalty in the U.S. in 1976, South Carolina has ended 44 inmates' lives, with these peaking in the early 2000s, when the state averaged 3 annually. However, the unintentional pause due to drug shortages and legal challenges has significantly reduced the number of inmates on the row. South Carolina's row population has dropped from 63 inmates in 2011 to 31 currently. This decline is partly due to successful appeals that resulted in reduced sentences for about 20 inmates, while others have passed away of natural causes during their time on gloomy row.
Moore has been on death row for 2 decades, and for the first time, we are hearing from him.
It happened. I wish I could go back and change it. There's a lot of things in my life I wish I could change. For the forgiveness of that particular is definitely a part of my life I wish I could change, because this is definitely the most, I took a life, I took someone's life.
That stay from the South Carolina Supreme Court have yet to be released.
We shouldn't be killing our own citizens. There's different ways that we can take care of them without making murders of.
As the debate over Moore's fate continues, his case shines a spotlight on the broader complexities of capital punishment in South Carolina. With legal, ethical, and procedural questions at the forefront, Moore's ending, or potential clemency, represents a pivotal moment in the state's capital punishment history. Whether Governor McMaster will maintain the state's unbroken streak of denying clemency, or whether Moore's case will spark a departure from precedent, remains to be seen. That's all for this video, folks. See you next time.